21 CR 094. I versus Melissa F. Lambert. Are you Melissa F. Lambert?
Yes.
Check. All right. Lambert is represented by attorney Ohio. The state is represented by prosecutor King. This matter was originally set for a trial today. The matter was continued after court performance order. Some new negotiations in progress, and matter was retained today for a status conference. Thanks for here. And this member has appeared. Now I have been presented with some documents here in this member that indicate that there's going to be a change of plea to a different charge. Trespass and habitation when the person is present or likely to be present. And I have a bill of information here for that charge. I know you talked to your friend this morning, but just explain to you, grand jury indicted you for burglary. I think that's on the charge for burglary. Yes. Grand jury is a group of citizens that live in this county that are selected to serve on a grand jury for a period of 3 months. And they meet about once a month or as often as necessary to consider evidence presented to them regarding alleged crimes that have been committed in the county. Now, the grand jury doesn't decide whether somebody's guilty or not. They simply decide whether there's enough evidence to warrant the case being sent to the court for the defendant to answer to the charge. And so there's 9 people on the grand jury. Since they don't make a decision as to guilt or innocence, only 7 of those 9 have to vote to return an indictment. And then it comes to the court. And that's what happened on the burglary charge. And you know that since then there have been proceedings, and you had an attorney appointed, and had motions, different things that happened. Now, the proposal that here is that you plead to a charge for which you have not been indicted. And it is a different type of charge, and it's called a trespass and habitation when someone is present, like to be present. And that charge reads that on or about January 25, 2021 in Huntington County, Ohio, you did by force, stealth, or deception trespass in a house, a permanent or temporary habitation of any person, when a person other than an accomplice of the offender was present or likely to be present. Violation section 2911.12b of the Iroquois Code, trespass and habitation when a person is present or likely to be present going to the 4th degree, and that's the charge. Now, you haven't been indicted for that. But so you're not required to answer that charge. However, there's a process that's available under the law by which a person can waive the right to have the case presented to the grand jury and agrees that come before the court on what's called bill of information, which is record. Now, waive means to give up in the legal sense. So, what a waiver in this case would do would be agree that instead of the charge being presented to the grand jury waiting for indictment, the case would proceed with information, and the information is simply basically the same. It would read the same as an indictment. The difference is it's not been voted on by the grand jury, it's just simply signed by the prosecutor. So it, in effect, replaces the grand jury, but it can only happen if you agree. Now, I have here then a waiver of prosecution by indictment, has your name and case number on it. And it reads that I, Melissa F. Lambert, having been informed by the court of my constitutional rights and my right to prosecute by the way of indictment, being represented by Catherine Hattner, attorney law, Hillsborough, Ohio, do hereby freely and voluntarily waive prosecution by indictment and agree to proceed in this matter by bill of information. It's dated 10/14/21. Yeah, that is today. Okay, now Monday's 21. All right. And then below that, there's a signature, and it appears to me the signature says Melissa Lambert. So is this document that you signed this morning?
Yes.
Okay. Now, when you signed it, did you understand that it was an agreement to give up your right to have this case, this charge done in the grand jury, and instead go forward today on this bill of information.
And have this charge replace that charge?
Correct.
Yes.
Yeah, the other charge then is gone, if you plead guilty to this charge. Does that answer your question? That charge will be dismissed.
Okay.
Yeah, because it's replaced. If any other questions you need to ask me, correct?
No, sorry.
No, that's not a problem. Anytime you have a question, just, tell me. Oh. All right. So, this waiver then, this waiver then replaces, or agrees that you'll be prosecuted and go forward on this bill of information rather than the indictment, which will, if you plead guilty, be dismissed. You understand that?
Yes.
Okay. And that's what you want to do?
Yes.
Okay. Now, the bill, the proposal is that you plead guilty. Under Ohio law, you have a right to have a copy of the bill of information 24 hours prior to being required to enter any kind of plea. And so I assume you just saw this this morning.
Yeah.
All right. And so the purpose of that rule is to allow someone to get served with a charge to have an opportunity to talk with an attorney or family members or somebody to prepare themselves to come to court. You've been heard of them on this happen all along. And so if you are willing to do so, you waive that 24 hours and we go forward today. If you don't want to waive it, then we have to come back tomorrow or a later date.
No, it's fine.
You agree we're going forward today? Yeah. All right. Now, the plea of guilty form I refer to here is a 3-page document that has your name, case number on it, and the prosecutor's office prepares this from a template they have in their computer. They put in the information relevant to your case, print it off. On page 3, there are signature lines, and about almost halfway down on the 3rd page, there's a sentence that says, "I enter this plea voluntarily," and immediately below that there's a signature line for defendant, and again I'm looking at Melissa Larry. That's your signature I'm looking at?
Yes.
All right. And you just signed this again this morning?
Yes.
Now, before you signed this, did you go through this, read it, and have and ask Ms. Hacker questions and have her explain anything about it that
Yes.
you needed to understand?
Yes.
Okay. Do you think you had enough time to fully consider this matter before making this decision?
Yes.
And had there been some discussion before this morning, or was this the first time you're able to talk about it?
This was the first time we talked.
Okay. Do you feel you've been rushed or pressured in any way?
No.
You feel you're okay in going forward with this position?
Yes.
Right? And are you entering into the agreement to plead guilty voluntarily?
Yes.
All right? Go over the agreement down on page 1. It states that you're going to withdraw your not guilty plea and then plead guilty to the following offense, count 1, which is actually, that should say bill of information, so BOI. So I'm going to strike that off because count 1 is actually the indictment. So let's put BOI. That stands for bill of information. Okay. Trespass in a habitation when a person is present or likely to be present. And it's violation section 2911.12b of the Ohio Revised Code. And the states you understand that that's a 4th-degree felony. The charge you currently are indicted for is a 2nd-degree felony. Carries a possible prison term between 3 and 8 years as a minimum set by the judge, and a maximum of half of that sentence as determined by the parole authority. So maximum of 8 years, and so parole authority keeps somebody for another 4 years or 12. That would be the maximum. This charge is a 4th-degree felony, and the possible prison term for that is a minimum of 6 and a maximum of 18 months. And there's also a fine available of $5,000. You understand that?
Those are the maximums. That's not necessarily what's going to happen.
Not the burglary charge. I was just explaining to you to show that it's been reduced.
Okay.
The burglary was a potential 8 to 12. This one, maximum is 6 to 18 months. Minimum 6, maximum 18 months.
Okay.
Okay? You understand that?
Yes.
You're not facing any felony charges anywhere else, are you?
No.
Are you currently on probation, community control, parole, or post-release control for a felony?
No.
Under the law, Ms. Lambert, if at some time you should be sentenced to prison for this offense, serve a prison term, the law provides that upon completion of that prison term, that the adult parole authority might decide to put you on what's called post-release control for a period of up to 2 years. So that means that if they did that, you'd be supervised by a parole officer on the terms they set. And if you violate those conditions, then they can return you to prison, even if you serve the entire term that's ordered by the court for an additional period of up to, in this case, 9 months for one or more violations. Now, there's a cap of half of their prison term. If it was a 6-month prison term, the maximum would be 3 months. However, if you committed a felony while you're under post-release control supervision, then in addition to whatever sentence will be imposed in the new case, the judge in that case is also authorized to impose an additional sentence for committing that crime while under post-release control, in this case, of 1 year or whatever time is left on the up to 2 years of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively the sentence in that new case. Do you understand that?
So does the post-release control, does that mean 2 years of non-reporting probation?
No. First of all, it's optional, it's not mandatory. The adult parole authority decides whether to do that or not. They could do it for 6 months, a year, up to 2 years. They would set the conditions. Most of the time, that doesn't include reporting. In fact, I think it always includes reporting. But it's to a parole officer, not to the probation department. So it's done by a state officer, not by the county. And then there's other conditions that they.
If I can interject, it only applies if you serve a prison term. If you're granted community control probation, then you don't have to worry about that prison control.
So is it going to be 2 years non-reporting probation, don't get in trouble?
We're getting to that point. What the judge is explaining to you now is that if you were to go to prison on this case, and the recommendation is for community control, if at some point you were to go to prison on this case, then the post-release control that the judge just explained could kick in. If you don't go to prison on it, then you don't have to worry about the post-release control.
And does he sign this today?
The post-release control?
Yeah.
No, because that only applies if you go to prison.
Okay.
So that clarifies it.
Here, let me try to help out. What we're talking about is 2 different things. They're similar but different. What I'm talking about, post-release control, only applies if you go to prison. So let's assume you get community control, which I'll get to in a moment. That's where you're supervised at the local level. And if you violate those conditions, then you can be sent to prison. And then, if you serve a prison term, then the adult parole authority could decide to put you under post-release control after you serve your sentence. So post-release control means supervision after you serve a prison. Probation or community control means you didn't go to prison, at least initially, and if you violated it, you could. And that's why I have to explain this to you. I have to give you the worst case scenario. And that's what we have to do. So, does that answer your question or explain things for you?
Yeah, but if I don't get in trouble in the next 2 years, then it's basically like non-reporting probation.
Well, that's different. I'll get to that point.
Okay.
Okay. So you understand that?
Yeah.
Okay. Now we'll get to what you're asking the question about community control.
Okay.
Under the law, I'm not required to sentence a person convicted of this offense to prison. Instead of sending them to prison, I can put them on community control, which is the word or term we use now for probation. That means that you could be put under the supervision of our county probation department for a period of up to 5 years under the terms and conditions that are set by the court. Now, if during the period of time that you're being supervised, the probation department feels you're not compliant, then they would file a written notice out to the court. There would be a hearing, and be given a copy of it, and a hearing would be represented by an attorney. If the outcome of that hearing at that time was that you failed to comply, then the court would go for community control, then sentence you to prison for 6 to 18 months, fining $5,000. And then, after you serve the prison term, you'd be subject to 2 years of post-release control supervision. So that's how that process works. Do you understand that?
Yes.
Okay. Now, the charge I read to you a moment ago You understand what it is the state's accused you have done in the bill of information and when, where, and how they alleged it?
Yes,
Did you discuss that charge with your attorney, possible legal issues, the evidence in the case, possible defenses to be raised in trial, possible outcomes of the trial with your attorney?
yes,
Are you satisfied with her advice and confidence in this matter?
yes,
Now, are you under the influence of any types of drugs or alcohol at this time?
no,
Are you taking any prescription drugs?
no,
Have any threats been made to get you to plead guilty here today?
no.
All right, now on page 2, toward the bottom, there's two plus lines that are printed in bold and underlined, and I'll read those. Defendant shall enter a plea of guilty to the bill of information. State will dismiss the charge outlined in the indictment. State defense jointly recommend community control. Is that your understanding of the agreement?
Yes,
Does anyone promise you anything other than that to get you to plead guilty?
no,
Under the law, the judge is the one who makes that decision as to what the sentence is, not the parties. And so even though there's an agreement, I'm not required to follow that if you plead guilty. I intend to, but I'm not required to. And so I could, in theory, sentence you to 18 months instead of giving you control. You understand that?
yes,
Now, do you hold any license or certification from any state of Ohio board that regulates any kind of profession or occupation?
no,
You have certain constitutional rights, which I understand, Ms. Lambert, before I can accept this plea guilty from you. First, you have a right to have counsel. Ms. Happer's been appointed to represent you and has throughout the case. Now, she wasn't appointed simply to try to work the case out, but to provide any defense that might be available to you under the law that you would like her to provide. And so, if you decide you don't want to do this, she's still going to represent you and defend you, including a trial, if that's what you want. You understand that?
yes,
All right, now under the Constitution, you have a right to have a jury trial in this case, on this charge. And that means that 12 citizens from this county would be selected from a group of people from the county summoned for jury duty on the trial. And after those 12 jurors were selected, the evidence would be presented. They'd be instructed on the law by the court, and then that jury would decide by unanimous verdict, between all 12 half agreed, on whether or not the state proved your guilt or proved beyond reasonable doubt. Now, if you didn't want to plead guilty, but you didn't want to have a jury trial, you can waive in writing, and again, waive means to give up the right to have a jury trial. And in that case, you would have a court trial, meaning the judge would be the one to hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proved beyond reasonable doubt. You understand that?
yes,
And under the Constitution, you have a right to confront witnesses against you and to cross-examine them for your turn. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else in front of you. After the prosecutor's done asking questions, your attorney has the right to ask questions. That's called cross-examination, and the purpose of that will be to bring out evidence that helps your side of the case. You understand that?
yes,
Right, under the Constitution, you have the right to use the power of this court to compel or force witnesses to come into court to testify for you, same as the state. So, if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court will issue a subpoena, which is a court order, that would require those people to come to court and be available to testify on your behalf if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
yes,
Now, under the Constitution, you have a privilege of self-incrimination, which means you cannot be forced to give evidence in this matter against yourself at any time, including trial. So, no one can ever make you testify. The judge can't, the prosecutor can't, no one can make you testify. It's your decision. Decide not to testify. The fact that you did not testify cannot be used against you in any way by any person. No one's even on comment about it except in one situation, which is if there's a jury trial, you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
yes,
Now, in the Constitution, you're presumed innocent until proven guilty on this charge by the state of Ohio on every essential element of the offense charge. What that means is that you're presumed innocent and you're not required to try to show you're not guilty simply because you're accused of the crime. In fact, under the law, at trial, you don't have to present any evidence at all in your defense. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt and prove beyond reasonable doubt on every element of the offense charged, which is the highest burden of proof is known under the law. You understand that?
Yes.
All right. Now, originally, you entered a plea of not guilty to the indictment, and you would have the right to enter a plea of not guilty if you were charged by the state in this case. And the plea of not guilty denies the allegations in the indictment, denies you committed any crime, and it exercises or invokes all of the rights that I just described for you. So, your plea of not guilty means you have a right to a jury or a court trial, right to counsel, the right to a jury court trial, the right to confront witnesses against you and to cross-examine through your attorney, your right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state, your right or your privilege against self-incrimination, meaning you could not be forced to give evidence against yourself and it could not be used against you in any way at any time, and your presumption of innocence, meaning that the burden of proof would be upon the state to prove your guilt at trial, prove beyond reasonable doubt, rather than on you. Now, if you change your plea from not guilty to guilty, or actually should say enter your plea since you plead guilty not guilty to the original charge, but in this case, if you plead guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, admits that you're the one who committed that crime. That plea waives, gives up all of the rights that I just described for you except one, the right to have an attorney. You always have a right to have an attorney at any time, no matter what your plea is. But with that exception, a plea of guilty would waive, give up your right to have a jury or a court trial. It would waive, give up your right to confront witnesses in open court and have them cross-examined by your attorney. It would waive, give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. It would waive or give up your privilege against self-incrimination because you're the one that's saying you're guilty, and that's what's used to find you guilty. It also waive or give up your presumption of innocence and your right to require the state to prove your guilt at trial, because if you plead guilty, they don't have to prove your charge. Plea of guilty also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal that you feel you may have had up to this point in the case. Now, if I should sentence you to the maximum sentence, under the certain circumstances, you file an appeal. It would have to be filed within 30 days of your sentencing entry being filed. Now, you understand all that?
Yes.
Ms. Lambert, are you a U.S. citizen?
Yes.
Right, and do you have any questions about the bill of information and waiver of the indictment or anything about the process that brings that charge before the court?
No.
You understand?
Yes.
You understand the charge and possible penalties?
Yes.
Have any questions about the plea? Okay. Any other questions you'd like to speak to Ms. Hackerman?
No.
Okay. Have any questions about the constitutional rights I've explained to you?
No.
You understand those?
Yes.
Any questions about the plea of guilty, what it means, and what the consequences of that will be if you enter the today?
No.
You understand?
Yes.
Is there any, do you have any questions about anything I've explained to you here this morning?
No.
Thank you, Ms. Lambert. Is it your decision to withdraw your not guilty plea, plead guilty to the bill of information charge of trespass in an application of a person present, likely to be present, pursuant to the terms of the written plea agreement that we just went over?
Yes.
And as to the charge which alleges that on or about January 25, 2021 in Huntington County, Ohio, you did by force, stealth, deception, trespass in a house, permanent or temporary habitation of any person. One person other than the obviously offender was present or likely to be present, violation section 2911.12b of the Ohio Revised Code, trespass, habitation when the person is present or likely to be present, a felony in the fourth degree, carrying a possible prison term between 6 and 18 months, and a fine of $5,000. How do you plead?
Guilty.
All right, the court finds that in this day in open court, the defendant was advised of all her constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11. Plea is accepted and ordered filed. Defendant found guilty of the charge and set forth the bill of information for the felony of trespass and habitation when a person is present likely to be present. All right. Now, I know that the records reflected there have been discussions with counsel and the court prior to today's hearing. My understanding is the defendant's now living in Kentucky.
That's correct.
Where is that, Hazard County?
I'm in Moorhead right now, but I'll probably go to Hazard too.
Okay. All right. And I see that there's not a request for a pre-sentence investigation, or both parties willing to waive that pre-sentence report and agree to have the matter considered by the court immediately sentencing.
Yes, Your Honor.
Yes, Your Honor.
All right, then the court will go ahead and proceed with sentencing. I will say that I normally don't do this, but I know given the nature of this case proceeding previously, that mental evaluation and so forth, the court had a good deal of information. I also see that you've not been convicted of the felony, have you, before? You had a diversion. I see that in Kentucky, but you were never convicted.
I think that's right.
Okay, are you on supervision for that at all?
No,
Okay,
that's been ever since I think 2018.
all right, yeah, we're back to 16. And so, and since she's living in another state, I don't see any reason to delay this any further and require her to return, so I'll go ahead and proceed. Mr. King, anything from the state?
Only was contained in the plea agreement, Your Honor. The victim in this case has been consulted with, and she is in approval of this agreement. Thank you.
Okay. All right, Ms. Sacker, anything you'd like to say?
Thank you, Your Honor. I would ask that you follow the agreement and place Ms. Lambert on community control. As you're aware, she is living in Kentucky and has been for 7 months now. So we would ask that she not have, and she has no vehicle, and most of the time doesn't have, I don't think she has her own phone, she occasionally borrows somebody else's phone to call in. So we would ask that you not require her to report back here on a regular basis. In addition, because she is indigent, she has no income, we would ask that you not impose any fines. And I know this is not, of course, normal policy, but we would ask that you consider suspending or waiving the court costs.
All right, Ms. Lambert, anything you'd like to say?
No, sir.
Now, are you, you're not on disability, are you?
No.
All right. When was the last time you were employed?
About 4 months ago.
Where were you working?
Candlelight.
Oh, okay. And you say you're staying in Moorhead right now. Who are you staying with?
My brother's his dad.
Okay. And is that your intention to reside in Kentucky?
Yes.
Well, it's ordered the court then that you be sentenced to a period of 2 years of control and supervision for probation department. And you're ordered to comply with these conditions. First, you obey all laws, all jurisdictions, and conduct yourself in all right and manner at all times. Now, immediately after court, you're revoked from the probation department and tell them that you've been put on in control. And there will be some different conditions that normally imposed. But we'll let you continue to live in Kentucky. But you are required to report to them when and as directed. I've got in here, you can report by phone until your supervision is transferred to the public. There'll be some paperwork I'll have to go through to get that transferred down there, so that part then, wherever you're living, you can report to the probation department that's supervising you there. And then they'll let the department up here know how things go. Must be truthful in all statements you make, questions asked by any supervising officer of the probation department during your control. You must keep the supervising officer of the department informed of the residence and place of one moment in time, not change either without prior permission. Specifically, deleting the normal requirements, you can't leave the state when you live in Kentucky. But you will have to cooperate with the transfer of supervision down there, so they'll probably have to go out and go in there and sign some paperwork. And if there's any papers they need you to sign up here to do that, but that has to go through a process where our state sends it down to their state and they have to agree to take your supervision.
I thought it was 2 years of non-reporting, don't get in trouble.
No, nobody ever said that. Now, you're to enter upon the grounds of any, you're not permitted to enter upon the grounds of any correctional facility or communicate with anyone with an inmate name without prior permission. You're not permitted to wander under the control to purchase, possess, use, or have under control any firearm, ammunition, dangerous orders, or weapon of any type. You're not permitted to purchase, possess, use, or have under control any kind of controlled substance, drug abuse, CBD, or great other variances that might have facts similar to those, or any device or instrument things that would be used to administer those rather than administration. Unless you have a valid prescription, if you do, you must provide your supervising officer with a copy of that. You're to submit to drug testing when it is requested. You're not permitted to purchase, possess, use, or have under control any alcohol beverage or be replaced with a sold, be consumed as otherwise lawful. You must report any contact with law enforcement or arrest, citation, conviction of the charge violating the law not later than this business day when it occurs. Provide them with financial information records of your ability to pay any fines, as well as property fine, and fees or costs to be reviewed. If you're referred for evaluation, assessment, or any kind of therapy, treatment, counseling, training, other programming, you're submitted to that. And if there's any recommendation for treatment, then you're to enroll in it and successfully complete that. There will not be a monthly supervision fee charge. You will be required to make court costs and make payment arrangements for that since you are able to work to get a job and make payments on that. There's no restitution. Now, being placed under any control rather than being sentenced to prison, you're deemed to consented to a search without a warrant of your person, residence, vehicles owned by you, used by you, or any other property places under your control, where you're found by any officer of the probation department. The order to pay court costs is also substantive, so if you don't pay those, or could try to cut this at first, means putting level in bank accounts, ways or any other assets. That doesn't happen, then the court could order you to do service and give you credit for each hour you work. In an hour, they set by the court, and each hour you work, you should judgment by that amount until they full. Now, in the event that it's alleged that you failed to comply with these conditions, then the probation department will file notice of that, serve a copy on you, you can have a hearing to represent an attorney. If the outcome of the hearing is that you have failed to comply, then at that time, the court could revoke your committed control and sentence you to a prison term of between 6 and 18 months and $5,000. If that occurred, and you serve a prison term, then post-release control in this case would be optional, meaning that the adult parole board would decide whether or not to put you under supervision for a period of up to 2 years under the conditions that they set. And if they do, you'll be supervised by a state parole officer. And in the event that you violate those conditions, then the adult parole board would return you to prison as a sanction to serve an additional period beyond that set by the court, up to, in this case, half of any prison term that was imposed by the court and served for one or more violations. But if you commit a new felony offense, then an additional whatever sentence the judge in the new case will impose upon you That judge is also authorized to sentence in this case to an additional period of 1 year, whatever time left on that period of post-conviction before whichever is greater. If that occurs, that has to be served consecutively to the sentence. And all right, that completes the case. The burglary charge is dismissed. As soon as you leave here, I want you to wait and we're going to make a copy of this entry that you take with you down to the probation department. And you'll need to go the.
Am I allowed to take that back and just go ahead and plead not guilty?
Say what now?
Am I allowed to take that back and just go ahead and plead not guilty? And have the jury trial?
Why would you do that?
Because you said 2 years or
I know,
2
I never
years
said that.
recording.
No one ever said anything about non-recording.
No, you said recording, and I thought that since I was living in Kentucky and to just stay out of trouble for 2 years.
You can call up. You don't
Because
have
It says you can record by phone here until it's transferred to Kentucky. Then Kentucky will tell you how often to record. And I don't know how they'll do it. They may do it, weekly, monthly, every quarter, and they get to where it's non-recorded. But that's a process that you work. Nobody gets non-recorded probation. That's not. I mean, why would anybody do that? I mean, why would the judge do that? Why would the prosecutor prosecute somebody? Makes no sense.
2 years non-recording and don't get in trouble.
That was never discussed. That was never mentioned. That was never no one's ever said that. You can't bring it up and say, no, that's not what I mean.
That's because I talked to her about it.
But you don't have to come up here, you don't physically have to come up here to report.
You're not coming back. I'm not going to make you come back to Ohio.
But
Unless you get in trouble, and in
I
this
don't
case, you'll be brought back.
physically have to go to Kentucky and report, and I live, sometimes I'm going to be in Hazard, sometimes I'll be in Moorhead. I'm going to be in Vanceburg this week. I mean, it's not like I have an address.
Well, that's something that you'll just have to deal with. It sounds to me like at this point in life, that's not true.
No, I'm telling you the truth.
All right?
What'd you say?
I said, it sounds to me at this point in your life,
Oh.
you need to start trying to have some stability. And quite honestly, being supervised by a probation officer is probably going to help you get it. Because you have shown some instability through your life. And, that's what this is intended to do, is to help you, not to hurt you. So, but we're not going to be coming back to Ohio, except by phone, until we get you transferred down to. That's the way it's going to work. All right, so just wait a minute, Avail will get a copy of this. You go legally down to the probation department, copy them, and then they'll get that paperwork prepared and send it. All right, anything further, counsel?
No, Your Honor.
All right, thank you. Go ahead and take it down and we'll get this Zoom hearing started. We're going to do Rackley, I was in.
Yep, we'll go on.
All right.
I'll go log in,
Right.
I'll go log in.
Okay.
Have them make,
Oh, you're on that one too.
have them make a copy of this too.
Just the sentencing. Yeah. Mr. Breeden, I see you there. Could you unmute there for a second? I need to tell you something. Mr. Breeden, are you there? You're muted. If you can unmute your mic. There you are. Can you hear me okay? Mr. Reed, can you hear me? I can't hear you. There it is. All right. I'm not hearing you, Mr. Reed. Let me check my mic here. Can you hear me okay there, Mr. Rackley? All right, but I cannot hear you guys, so I am apparently having an issue here with my volume or. Mr. King, can you hear me? All right, I cannot hear you. Something's wrong with my mic here. No sound here. I can't hear anybody. They can hear me, I can't hear them.
Try it now, Judge.
Yeah, don't sound again. All right, this is case number 20, CR 250, State of Ohio versus Andrew Rackley. You're Andrew Rackley, appearing by video there at jail.
Yes, sir.
All right, this hearing is being conducted by Zoom because of the COVID issues. And Mr. Rackley, as it says, appearing by Zoom from the jail. His attorney is back to Hacker, appearing from her office, and Assistant Prosecutor King, appearing from his office. Also, we have two representatives of the probation department that are present for the hearing. Now, Ms. Hacker, you and the client both agreed to waive the Zoom person presence in the court and conduct this hearing remotely.
Thank you, Your Honor.
And that's all right with you, Ms. Rackley?
Yes, sir.
All right. Mr. Rackley was convicted of grand theft of motor vehicle and sentenced to community control back on April 22nd of 2021. There was a notification of alleged violations filed on October the 5th, alleging that the defendant had failed to comply with the conditions of community control that proposed. The court notified Mr. Rackley of that hearing, or of that allegation, appointed the staff to represent him, and set the matter for an evidentiary hearing today, and that's what we're here for. Ms. Hacker, again, an opportunity to review these allegations and consult with the client about the matter.
I have, Your Honor.
All right, and see what's that hearing, and we'll be admission.
Your Honor, he will admit, he denies that he overdosed on drugs at Turtle Creek, but he will admit that he did consume methamphetamine while he was at Turtle Creek, and that is a violation. He would also admit that he has not paid any restitution. However, because he'd been in Turtle Creek, he wasn't able to work and earn money to pay that restitution.
And he acknowledges he was discharged from the facility?
Yes, he does. Correct.
Yep. Mr. Rackley, you have a right to have a hearing on these allegations that were filed. And the allegations were filed on October 5th, alleged that you violated Rule 7, in that on 9/29/21 you were found unconscious in Turtle Creek treatment facility and was administered Narcan, and then became responsive and tested positive for several illegal substances. Rule 18 is that you not made restitution, which we've been in custody, so that's understandable. Rule 19 is that you were discharged from Turtle Creek due to your overdose on 10/5/21, and the requirement to successfully complete the treatment plan. Now, you're entitled to have a hearing in which the state will have to present evidence that proves that these allegations are correct. You're entitled to have your attorney cross-examine the witnesses that the state will present in a hearing today to try to bring out evidence that will help you. You're also entitled to present testimony on your behalf, although you're not required to do so. You can't be required to do so. Including, you're allowed to testify on your behalf, but again, you can't be forced to do so. And if you don't, that won't be an issue. Now, in the event that you're found to have violated these conditions, whether it be through your own admission or by a plea, by a hearing, I can do one of three things. I can continue community control under the same conditions that I previously ordered. I can continue it with additional conditions that I think are appropriate. And the third and most serious is I can revoke your community control and send you to prison for 18 months and fine you $5,000. Now, do you understand that, Mr. Rackley?
Yeah.
And has anyone promised you anything, or correct you in any way to get you to admit to these violations here this morning?
No.
All right. Do you have any questions at all about the allegations or your rights?
No.
All right, then, are you admitting to the allegations that were filed in the notification that we just went over?
Yeah.
Did you say yes?
Yes, Your Honor.
Okay. All right. Now, is there anything from the state or the probation office regarding this position?
Yes, Your Honor, thank you. Given that this is the defendant's first community control violation, and that there's clearly some serious ongoing substance abuse issues here, the state and the probation department would ask that he be continued on community control and in order to complete the STAR program. Thank you.
Officer Kelly, have you talked to STAR to see if they would, accept him?
Your Honor, at this time, I have not. I did have some contacts to get in touch with them to advise them of Mr. Rackley's condition to see what they would suggest at this time.
Okay, excellent. All right. Anything, Ms. Hacker?
Your Honor, I did speak with Mr. Rackley about STAR, and he indicated to me that he is interested in that, and he would like to have that opportunity to be continued on community control and to complete the STAR program.
All right, Mr. Rackley, anything you'd like to say?
No, Your Honor.
All right. Well, obviously you do have a serious issue. You've been overdosing down at Turtle Creek. So it is the order of the court that you be continued on community control with additional conditions. First of all, you are going to be required to successfully complete STAR program and any aftercare, assuming they will accept you. If they won't accept you, then we'll put you in an alternative treatment facility, complete a residential treatment program and aftercare at that facility. For your own safety, you're going to remain in jail until that's available. Probation department will immediately contact STAR and see if they'll accept you. And as soon as that's available, as soon as they do, you'll be transferred down there. Usually it's about 2 to 3 weeks. It just depends on what's going on. I'm not sure. It goes in cycles, goes up and down. And you'll also be required to take any additional work. All right, is there anything further from counsel?
No.
All right, you'll remain in jail and Mr. Rackley until there's a bed available for you. Thank you.